Outstanding. Well, I want to say thank you up front to the Mid-Minnesota team for the opportunity to interact with you all a little bit today. We do have some goals for this session, and that begins with providing some information in interaction on educational format that allows you to consider the benefits of estate planning, what an estate planning is, and how it actually can help you and your family and loved ones. My name is Linda Grau, and I'm a member of the Legal Karma team here to provide as much information as I can. I thank you all for the questions that you did advance, and I will make every best effort to answer those questions as we go along. Again, please feel free to put a question in the chat, and we'll keep up with those questions and try and get as much into this hour as we can for you. So I want to start by talking about what an estate plan is. And we have a lot of ideas and some preconceived notions, and in some cases, some confusion about what an estate plan actually is. It is, in fact, a set of reliable legal documents that will allow you to do two principal things. One, to grant authority to a trusted loved one to make financial or medical decisions on your behalf in situations where you're not able or available to make them yourself. And it helps you create a legacy that allows you to lay out your intentions for how you would ultimately like your assets and the things that are precious to you to be distributed when the time comes. We know a lot about estate planning, and one of the things that we know that we find unfortunate is that about 2/3 of Americans do not have an existing estate plan in place. We also know why. There's often a lot of discomfort about thinking about and planning for some inevitabilities that cause us to step back or step away from the opportunity to create an estate plan. It makes that discomfort can be a barrier that's really hard to overcome. But it is also, we find that a lot of folks have some preconceived notions about estate planning and about the benefits of estate planning. Some folks think, well, I don't really have any money, or I don't have any ability to cover the cost of creating an estate plan because they assume that it's really expensive. And you couple that with the discomfort, that ick factor, that feeling of, I don't know if I want to talk about or think about these things. And the proposition of creating a plan becomes overwhelming. It's important to talk about two things. What happens if there is a plan? What are the benefits of having an estate plan in place? One benefit may be I can help my loved ones avoid a probate situation or a lengthy court process that involves a judicial officer making decisions about my assets and my estate, or the judicial officer is left with having to appoint folks to act on my behalf. Those processes can be time consuming, they can be expensive, they're very intimidating in a lot of cases, and not having a plan can make that probate process part of the unenviable future. With a plan, not only can I potentially avoid a probate situation for myself and my loved ones, but I can also utilize certain aspects of an estate plan to protect the assets I do have, or the equity I do have in the assets I hold. It will also give me an opportunity to appoint and authorize folks who I trust, who know me, I feel confident can carry forward my wishes and intentions and make decisions in the manner I would want them made. Without that, there is a whole bunch of confusion that can be created. That lengthy, expensive, confusing, and intimidating court process can kick in. Nobody knows what to do. Nobody knows who should do it. When I create an estate plan, I'm taking the mystery and the uncertainty out of all of that for those I love and who care about me. Another benefit of the estate plan is that I get to decide who will act on my behalf. I can list, appoint, and authorize my trusted loved ones to take actions on my behalf, that I can give them instructions and directions that outline my wishes and intentions and tell them where I want them to go with these wishes and intentions through the authorities that I've granted. We'll go back here. Basically, an estate plan is drawing a map. It's giving those who are able to care for us and assist us an opportunity to know where to go, but still have my voice as the GPS saying, this is what I want. This is my wish. This is my objective. So, in essence, we're empowering the folks that we trust to make those decisions, to get on that journey, and to be guided by my wishes and intentions, not those of a court or of someone who may not be as familiar with me and what's important to me, making those decisions. The objective is to create a comprehensive estate plan that allows those that we love and those that we trust to be able to manage through unexpected hazards and detours. Life happens, things can be very challenging when medical situations arise, health situations, either temporary or long term, can require different levels of attention or approaches. There may be opportunities where finances are impacted by those health situations. We want to make sure that the plan that we have in place for ourselves is comprehensive enough to empower everybody to manage all aspects of any particular event, or whether expected or unexpected. So I mentioned a comprehensive estate plan, and that's there. And I've mentioned that this is a set of reliable legal documents. There are multiple documents contained in most typical estate plans. We hear about revocable living trusts, last wills and testaments, powers of attorney, healthcare directives. All of these documents are separate and provide different levels uh, of purpose, but they oftentimes work together to make sure that things are covered, that actions and transactions can be made as necessary, and that we've empowered folks to make those critical healthcare decisions for us when we can't make them for ourselves, or to assist us in making them when we don't want to be alone in making a decision for ourselves. So I'm going to talk a little bit about what these documents actually are. We had quite a few questions that came in advance of today's event about what's the difference between a will and a trust, and how do those things work. Also had some scenario questions that, as we go, I'll include in this. But first, I'm going to go through and define what the documents are. So these are standard documents that exist within an estate plan. So a financial power of attorney, which is sometimes referred to as a general durable power of attorney, is the tool that is in the toolbox that enables you to appoint an individual or individuals. You can do it in succession. So if one can't serve, someone else can step up to manage financial affairs, manage assets, help out with transactions, take on the responsibility and have the legal authority to act either immediately when you sign the document, or later if you are ever in a situation where you can't make decisions for yourself. Similarly, healthcare directives do the same thing, but for medical considerations, end of life considerations, and the like. So I can appoint a person or a group of people in succession or together to assist the medical professionals who are making decisions for me when I can't make them myself. And they will have the ability to interact with the medical professionals, receive information about care, diagnosis, options for relief. All of those authorities are built into the document itself. So I want to talk briefly about a last will and testament. A last will and testament is basically a checklist. It's my intention that these assets that I hold are distributed in this particular way. This is who gets what. And it also has an important feature, allows me to name what's commonly referred to as an executor, sometimes called a personal representative. That's the person or people, the trusted loved ones, that I am empowering to take these actions to fulfill that checklist. Now, a trust is commonly a part of an estate plan, but very different from a will in that it does two important things that a will does not. One, it creates an entity. And by entity, that can be a little divisive because it's a little bit more of a legal term, but it is a living document. That means there are assets that you control during your lifetime that you can title into the name of your trust or take them out of your trust to sell, invest, expand. You are the trustee of your trust. You have full control over the entity that you've created that can hold your asset. Why is that important? Some folks like the idea, and it works in that situation, to have a trust that creates a little bit of liability protection because, as an individual, if I have a trust, I have control over my assets, but the trust actually is the owner of my asset. So if I want to put my house or my vehicles or other property into the name of the trust, I still have control over them during my lifetime and the ability to sell or transfer or manage those assets as I see fit. But it provides a little bit of a barrier between me as an individual and my trust and me acting as the trustee of my trust to manage those assets. The trust also allows me, not unlike a will where you appoint an executor to handle and carry out the wishes detailed in the trust, but it also, for a trust, allows me to appoint a successor to me as trustee of my trust so that when I'm no longer able to manage my trust or the assets that are held in the trust, the successor trustee or trustees can move forward with the authorities they need to follow my wishes. And this is where it becomes solely about how much control you want to have over the distribution of those assets. Some of us have minor children, and in many states, minor children are unable to accept ownership of real property. There's a lot of reasons for that, but the most basic one is a minor child is not a taxable party and cannot be someone who's obligated to pay taxes on a piece of real property. So if you had a home that you wanted to title into the name of the trust, you can control that asset being available and held in the trust over a period of time until those minor children are not minors anymore and can take ownership of the property and also that tax responsibility. That's just one of many examples. Some of us have family members or prospective heirs who have special needs, and maybe they're receiving benefits and care from state-funded or government-funded programs that are based on their asset or income level. So I don't want to create a situation where I'm leaving a legacy for that heir, and that causes them to lose access to that benefit or to that care. I can place that that legacy or that distribution into my trust and ask that my successor trustee hold that money or that asset in the trust for the benefit of that heir. So they're not assuming ownership and risking their eligibility, but it's there, and the successor trustee can use that asset for the benefit of that beneficiary. Not sure how good the audio is if you can hear my dog scratching at the door and making noises to try and get my attention, but my pets are very important to me. One of the features of a trust is that I can make arrangements for their care if at some point I'm not able to care for them myself. I can make sure that they go to a loved one or to an organization that supports pets and can make sure that they get the proper care that they need. I can set aside funds and provide direction and instructions to my successor trustee on how they'll be cared for. Some of us have our own businesses that we've spent many years, blood, sweat, and tears, 24 hours a day, keeping our businesses going. We want to make sure that there is a legacy plan in place. It's not the only option, but a revocable living trust can help me set up a legacy for not only the management of that business, but who ultimately receives control and ownership of the business. Let me go back to the question that I started this with real quick. What's many of you asked, what is the difference between a will and a trust? And some of you asked, which is better? Okay, so better is a relative term. Everybody's estates, everybody's portfolios, everybody's assets, and everyone's wishes and intentions are often different. So one of the things that I always like to break it down as basically as I can. A will is a legal document that says who gets what. A trust is a legal document that says who gets what and how. So that goes back to that amount of control that I mentioned. Do I want to delay a distribution until my children reach the age of 40? I love my son. He's 27 just a couple of days ago. I'm fairly confident that he does not have the maturity yet to be able to manage my estate portfolio. It's not a judgment. I just know my kid. Okay. So I want to make sure that I'm not setting him up to fail and that there's a legacy for him. I can, in a trust, have enough control to say, I would like him to receive the distribution of the assets of my estate when he's 40, and my successor trustee will manage that trust. So the difference is the level of control and how those wishes are carried out. One is not better than the other. It really comes down to what your needs are for providing for the future of your estate. And if you want to pick up that liability preservation, you want to put a barrier between your assets and yourself personally, people say, well, why does that matter? Well, there's a lot of scenarios that can come up. Maybe I'm involved in an automobile accident, and there's someone who is looking to get a judgment that attaches to the value of my assets. If I own things individually, that's a different process than if things are attached through my trust. So one of the things that comes up, and there were some questions that I'll also touch on about what happens if I have a family member who I have named as my beneficiary, and my spouse is also a beneficiary, and we all pass at the same time. What happens? Every state has their own laws that recognize how that's to be interpreted in the very unlikely event that something like that happens. There are not provisions in the trust that will get in the way of state law. So to the benefit of the estate, a will or a trust is going to provide the instruction, and the state law in those very rare circumstances would be applied. The other thing that comes up a lot is, how do I decide who I appoint as my successors or as my agents or as my personal representative? There's a couple of things that we'd ask you to think about just to plant some seeds. One is, if you're going to be empowering somebody to make decisions on your behalf, are they available presently physically in a relative location, or can they be where they need to be to handle those matters for you? So if you have children or siblings or other folks that you want to appoint, are they able to be where they need to be in order to facilitate or take those actions that you're asking them to take? Another thing to consider is those individuals' life skills and expertise. A lot of folks will say, well, I don't want to name one of my children because the other two will be upset or they'll be hurt that I didn't name them. Well, maybe that one child is an accountant or has experience in handling financial matters personally and professionally. And and it's a balancing act. Like, do you want to have somebody that's acting on your behalf that has the expertise, or do you want to have the others have the confusion of not having that expertise and trying to manage your affairs? Also, you may want to ask yourself, are they willing? Are they willing to step into that role? I have different folks in my life, some who just really want to help, but don't feel comfortable with the ideas of having to help. And so they may not be the folks that are necessarily best situated to act on my behalf. There's another reality here, and I mentioned it when I mentioned, alluded to it when I mentioned that some folks are going to react differently. These tools normally do not get implemented or used until there's a situation that is very likely having an emotional and challenging and scary and uncomfortable situation for all of our loved ones. And dynamics change under those circumstances. I have worked with thousands of members over the years, and some of them have said to me, oh, well, everybody gets along great. And until these decisions and until these authorities kick in. And then dynamics don't necessarily play out the way that we want to. If you already know that there is hesitation between folks that you might consider appointing, don't appoint them together, right? We don't want to have the estate plan set them up for failure or give them distractions that would require them to go to the court for clarification. There's a couple of other things to remember. These documents, the type of documents that we're talking about, a revocable living trust, a will, a power of attorney, or healthcare directives, one of the benefits of them is that as life changes, the documents can be updated or amended to incorporate change. So, for instance, if I create a trust and I have grandchildren that are born after I create the trust and I want to set up a legacy for them, I can go back and amend the distribution of my trust. I'm not solving for forever in one day, right? So maybe I have other family members who over time become incredibly successful and they're thriving, they're exceeding their objectives and goals about the life that they've established for themselves. And you have others that don't, that you want to help them get to the next level. You can go back later and adjust distributions. You can go back later and change out the agents. Someone that you've named moves away and you want to have somebody step in who's local. You can make those adjustments as needed. The thing to remember is that this estate plan is outlining and creating that map. We're giving your agents and your heirs the ability to understand and see in writing and have directions to follow to fulfill your intentions throughout. Another added benefit of the documents is it helps your asset holders and financial institutions know what those wishes are as well. So they're not operating in the dark either. Our goal with an estate plan is always the same, to give you the comfort and confidence of knowing that there's a plan in place. When we get to the finish line, we don't have to worry about what's going to happen next because we have established a plan that lays all of that out for us. I would love to jump in and switch over to those questions that you guys sent me in advance, but also check out some other information in the chat and see if there are additional questions there. If anything that I've offered prompts another question, please feel free to put it in the chat. I am going to go through this list and see other questions. So we have some questions about the difference between an irrevocable trust and a revocable trust. It's a common question that we get. An irrevocable trust appoints specific entities or individuals to manage a trust that cannot be changed. I mentioned the estate planning documents that I was talking about can be amended and adjusted by you as the person who creates them. An irrevocable trust cannot. So part of the reason we didn't talk about irrevocable trust today is that that is really locked in. It is chiseled into stone. And those kinds of estate plans really do require the benefit of advice of counsel, often tax practitioners to be involved or a CPA. So those are very definitive and they cannot be changed. Let's see. Does a will ever expire? Well, no. However, it can be terminated by the creation of a new will or an amendment to the earlier will. There may be some concerns about the length of time that's transpired. There may be additional assets that are not referenced in the will. Those kinds of things would need to be worked out if it was created 30 years ago. But it would still be effective. It would still be recognizable by the law. But it may not completely capture all of my current wishes based on what's happening in my life now or what's happened in the last 30 years. Does the program provide information about where to file documents for a trust? So there are a number of things that happen when we create a trust that require a little bit of follow-up work once the entity is created, once the trust exists. For example, I mentioned titling my house over into the name of the trust. That's a separate act that I have to give notice to the county that the property is located in, that the trust and me as the trustee of my own trust, we are now the taxable entity. We are the ones that are responsible for the taxes, but it's the trust that holds ownership. That is usually done through the recording of a deed that lists me as the trustee and my trust as the owner of the property. There are also accounts that I may hold, whether they're checking and savings accounts or other accounts where I've listed a beneficiary, where I may be able to have the trust be the owner of an investments account, for instance, or be the beneficiary of my investment account. It would be my responsibility to go notify that asset holder that I now have a trust and I would like the trust to hold ownership or to be a beneficiary, whichever was predictable or applicable, I should say. Let's see. Okay, here's another good question. Does the TOD on my deed avoid probate on my house? So a transfer on death being associated with one or more of your accounts is going to result in the direct distribution for that transfer. So if I say I want this asset to be distributed to Jim Smith, then Jim is going to directly receive the transfer of that asset. There isn't a probate correlation to that process. Now, there could be, because if, let's say, uh, Jim's son thinks that they should have been the recipient of that, that's a whole separate process. We can't stop Jim's son from taking an objection or to making a request to the probate court for an alternative action. But here's the thing about a TOD form, about having a will or a trust. My voice will be in that probate proceeding if Jim's son challenges the decision that I made through the documents that I've prepared. So if I signed that TOD form and it's notarized and it's a part of my asset holder's record, there's really no question about it. If I have made arrangements in a trust and somebody from the outside of that comes in and says, I should inherit this, or I'm the favorite niece and I'm not named in this, but I should be, there's provisions in the documents that allow the court to recognize you expressed your wishes in a legally reliable way. Therefore, it's going to reflect for that judicial officer what your intentions were, that you did that intentionally with capacity, and that will help them and aid them because they're able to rely on your voice as reflected in the legal documents. And we had several questions in the pre-submitted questions about things that might involve joint ownership of property with a spouse, a car, a home, that kind of thing. There are types of ownership that enable you and a spouse or you and another individual to share what's called a right of survivorship. So I can tell you on an auto title, it will sometimes say, this car is owned by Linda and or by Mike. So if one of us passes, the other continues to maintain ownership of the vehicle as their own sole and separate asset. In relation to real property, that's normally what we call vesting. The title of a property will say who owns the property, whether it's together, whether there are rights of survivorship or not. And that's what's typically followed on who maintains ownership after one co-owner passes or not. There were questions about gifting assets to others as we age. If we have a trust and we choose, while we are the trustee of our trust and in control of full control of our assets, to make gifts, that is fully our prerogative. We don't lose the ability to manage or facilitate our own assets while we are living and in control of our own trust. Does a trust protect assets from individual debt like nursing home, hospital bills, lawsuits? It can, but that's ultimately one of those things that's going to depend on the contract that's entered into when services are being received. So that wouldn't be specific to the trust. The successor trustee would be the one that would have the ability to work through those legal and billing processes on your behalf. Here's another question in the chat. If you've transferred a home or property, is there an option to give one kid a higher percentage than another? These decisions are wholly yours. You can create and control the distribution of your assets through the estate plan in any manner that you choose. And you can make that decision today and then change it later. What else? Let me just scan this real quick. Any other thoughts or questions you might have? Any follow-up questions to something I've offered with the information today? I did note in the trust that there's a question about whether or not the presentation will be distributed today. Yes, it will. I'll let you know as well that included in the materials that will be distributed is an index that talks about the type of documents that are often included in the estate plan and just gives some plain language information about what each document is and what it does. Question about POA versus executor. Does a POA end at death? Yes. So if you, and that's again a reason why it's important to have a comprehensive estate plan that serves you during your lifetime and after. So a power of attorney, particularly that financial power of attorney I discussed earlier, does expire upon our passing. That is for a couple of different reasons. That's when, if you have a will, the will takes over, and the successor or the executor named in the will would then be managing the financial affairs of the estate. They may be the same person, but they're different roles. And so the documents are designed to make sure that one ends where the other begins. Can a property in a trust be at jeopardy if needed to go on Medicare for long-term care? So jeopardy is a scary word. There are a number of different tools, other estate planning tools that can help when long-term care initiatives kick in. I mentioned the needs of the considerations and some of the factors around special needs beneficiaries. You want to make sure that you're not losing eligibility because you own a home. There are benefits of having those assets isolated in a trust so that they're not counted as eligibility, but that would ultimately come down to the agency, Medicaid, or others who are making the decision about eligibility. And in my experience, typically, they will share information about what options you have to preserve yourself for long-term care through Medicaid and other services. So there's a question in the chat about if a POA ends but no executor is specifically noted and the will is simply a list of assets, then what? Well, if there's no executor and there's a list of assets but nobody knows what to do with them or what your intentions or wishes were for those assets, it's likely going to result in a probate court action to make those determinations. Where do we get a fee schedule for documents? So when you go into the solution that's available through Mid-Minnesota, you'll be provided with information, a full list of what the comprehensive packages are that are available, what's contained in those packages, and how much they cost. That's upfront, very transparent throughout.
Linda, can I chime in there too?
Yes.
Yeah,
Yes,
if
please.
you on our website under on the Wills and Trust webpage and on the follow-up email, there'll be a link to that. That information is published there too. So before you even log into online banking, you could see that there. Becky had a similar question. It was right above the power of attorney one that you just answered. I just want to make sure that you saw that. That's asking about cost as well.
Right. Go to the website. There's so much information there. Let me tell you this too. When you go click on the link that says "Get Started Now," you'll be taken to about a 2-minute interaction tool that will help you learn more and identify what your priorities and objections and intentions may be in a way that will help sort through and identify what may work best to meet those objectives and those intentions. I do want to talk a little bit more, thank you, Mark, about having beneficiary designations on an account versus having them listed in a will or a trust. So a will and a trust is going to give direction and provide instruction about all of your assets that don't have a designation on the account. Now, you may be in some instances, depending on the account type, able to list the trust if you have a trust as the beneficiary. That would then result in the transfer going to your estate, and the successor trustee that you've appointed would be able to allocate that asset as you've directed in the trust. If you have a beneficiary designation on an account and it's not listed in the trust, or it's listed in the trust or the will, and they conflict, there'll be a decision made by the asset holder. Typically, it's to follow the beneficiary designation. So that is what they're relying on in order to distribute the asset. It does come up that sometimes, maybe in that example where we created a will quite some time ago, now we have a new asset. We didn't think about it when we opened the account. We listed our children or a child as the beneficiary. Now some things have changed. Those things would have to be sorted at the time of the distribution by the asset holder, but most likely they're going to follow the beneficiary designation first and then rely on the will or trust as the second layer of preservation. Okay, this is a great question. KG, thank you. When and how might it make sense to sign a house over to a child? Is there a better or specific way to do that? Well, there's a couple of considerations that you want to have. If I'm still living and I transfer my home, if I title over my home to my child, my adult child, they are now responsible for the taxes. I am no longer part of that decision. However, they are also, any liabilities that they incur can now be attached to the home that I'm still living in. So if I title my property over to my son and he gets in a car accident and there's a judgment issued against him, my home where I live, although it's his home now, may be subject to that liability and that judgment, in addition to him incurring the tax liability. So it really is a personal decision, but those are definitely factors to consider when you're deciding whether or not to transfer it and when to transfer it. Any other questions that I've failed to grab onto for you here? One of the things that you'll find when you go to the website or you click into the solution and you start through the process of making some choices and decisions is that you'll see that there are a couple of ways to get some support, get some additional questions answered. I work with a super dynamic team of specialists who can answer questions if you aren't sure about certain terminology or you're interested in finding out more about factors you should be considering about a particular question. There are tooltips or learn more links that will give you some examples and some additional information, or there's a phone line that's dedicated specifically to Mid-Minnesota members. You can pick up the phone and call. The specialist will gladly help you out. Also, if you feel more comfortable going through the process with somebody on the line, those customer support specialists can receive an appointment. There's a link where you can go in and schedule a specific time to talk through your questions and concerns and go through the questionnaire with somebody there with you to answer any questions that may come up as you go along. We pride ourselves in providing as much information and knowledge as we can. We want you to make really confident decisions and feel comfortable about the process so that you can feel that relief that there's a plan in place and that you can go back as needed and make adjustments and changes, or you can go back and ask questions at any time. Just to be really clear, there is no cost associated with placing those calls, sending a live chat message, or scheduling an appointment. All of that support and service is included in the offering. So you're not going to get a bill for talking to somebody. We want you to be confident and empowered in this process and feel like you've had the benefit of all the information you need to make those choices. Oh, yay, McKinsey. Thank you. There's a note in the chat celebrating McKinsey's helpfulness. How else can I help today? Well, let me just say thank you again for the opportunity to share this estate planning solution opportunity with you. Again, thank you to the Mid-Minnesota team for giving me this time. We value and appreciate your time and are looking forward to being able to help you create that estate plan for yourself and your loved ones.
Thank you, Linda.
You bet. Thank you.